Good afternoon and good morning to those of you that have joined us from abroad. Thank you so much for joining us today. As always, we have another great session with Lee, and Lee is going to be giving us another update. And we'd like to know a little bit more about yourselves and who's joining us. So please feel free to put a comment in the comment box about where you're from and introduce yourself. We've received some great comments from previous sessions that Lee's done. So thank you so much. And I think a few of you are regular joiners. So as I said, introduce yourself in the comment box, and it'd be great to get to know where everyone's from. So I'm going to pass over to Lee. So thanks again, Lee.
Thank you very much, Mel, for that introduction, and good afternoon, everybody. For those who are just joining this session for the first time, we run these monthly at GPA, and Mel and I thought it would be a good idea really to cover those things each month that are included, like changes in legislation, new HMRC publications, things that are upcoming. Just because we know life is very busy for everybody, and sometimes months can go by and you are out of tune with what's going on. So this session's really about that. It's for payroll and HR, covering relevant tax and legal issues to help you really do your day-to-day work more effectively, and to prompt ideas and thought and so on. So brief introduction. My name is Lee McIntyre Hamilton. I am a global mobility and employment tax partner. I'm the resident global mobility tax expert for GPA, and I'm also a tax partner at Keystone Law. So the first bit I'm going to cover is an overview, and I do this at the start of every session. We went into some detail last month. We're not going to this month, but really this is about just setting the landscape, what's happening out there broadly in the economy, which is affecting how employers operate and so on. So I've put in some broad themes which we'll just revisit again. And my expectation is that these will evolve over time, hopefully. But obviously the change is slower with long-term things. So, the first area we looked at last month was increased employment costs. So employers will have coming in at the start of April, increased NIC, national minimum wage is increasing, plus other benefits which we'll come on to, like statutory sick pay, etc. So there is increasing costs coming down the line for employers. Of course, also there's the cost of living as well, which is going up substantially, especially in light of what's happening currently in Ukraine and globally, unfortunately. And whilst that is going to affect employees, of course, there's a knock-on effect for employers expected in terms of increased wage demands and pressure on employees as well, in terms of their net income. There's also the increasing compliance burden. And that really is due to, I think HMRC is coming back alive again after COVID in the last 2 years. So it's revisiting things now like IR35, compliance and so on. It has more resources to devote to these things. And so over the next year, 2 years, we can expect, I think, a real uptick in compliance activity for employers when it comes to HMRC. Of course, the big challenge at the moment is labour shortages. We have had a little bit of an ease up for employers with regards to Omicron. The numbers are going down now, so there's not as much sickness, but still there is huge churn in the market with the Great Resignation, so-called, and also just generally there not being enough skilled people for many to fill many types of roles. And finally, pressure on employees. And I just wanted to mention that because, of course, that does affect all employers too. The cost of living pressures that are happening currently, increased pressure with regards to hours when there's not enough labour out there, and also things like financial well-being. So that's a brief overview of the employer landscape, as it were, from my point of view, and what in terms of what we're seeing as well within GPA. So with regards to tax, then. I just want to update on a few things which have happened in February and which have, caught my attention, and I thought it would be useful to share. The first I did mention last month, but HMRC have reiterated this, so clearly they're in fear that people are going to get this wrong. But where you're an employer and you have made claims under CJRS or the Eat Out to Help Out scheme, then do remember that those claims and the income received from those claims must be included on your corporate tax returns, the CT 600, as income, basically, when calculating your taxable profits. Now, after 6th of April 2021, there was a specific box on the corporate tax return form included for people to include those. But prior to April 2021, there wasn't. And so I think there is concern that it's been missed by employers. Now, not specifically a payroll responsibility, but something certainly to flag with your finance department or whoever takes care of your corporate tax filings. The second thing I wanted to mention was grossing up benefits and expenses via payroll. HMRC have rehashed and publicized their guidance with regards to grossing up income. So I thought I'd just revisit that in a little bit more detail. For those of you who've not come across that concept, really, it arises, the whole gross up point with payroll arises where the employer is picking up tax on the employee's behalf. So an example would be an employer provides a taxable benefit. Let's say it's accommodation near a permanent workplace. It pays that on behalf of the employee, but it also says, well, actually, as an employer, we're going to pick up the tax on that too. Otherwise, it's not fair because we're covering the benefit, but you're going to be subject to tax on that benefit. So the employer covers the tax on that too. Now, what happens? You get one of them very kind of a bit strange for me, at least as a non-mathematician, iterative formulas where you have the tax on the tax on the tax because the employer's paying the tax on your behalf. The tax in itself becomes a benefit. And that's where the gross up comes in, because the gross up calculation essentially works out what the tax on the tax on the tax, etc. is, and therefore what the employer should be paying across to HMRC. So let's have a little look at that in a bit more detail. The way in which employers deal with gross ups will differ depending on how the employer has basically provided the benefit. So firstly, if the employer reimburses expenses to an employee, then those reimbursements should be via payroll, where they're taxable benefits, subject to pay as you earn and NIC, just like any other income. So if your employer provides say you went out and you had a party and you bought wine and cheese and so on, hopefully not during lockdown like some, but you bought those and then you put those receipts into your employers and they said, okay, we're going to pick up the cost for you of that. Your employer reimburses you the cost of your wine and your cheese, great. What the employer then needs to do is include that reimbursement via payroll, subject to pay as you earn and NIC. Now, obviously, that then has a knock-on impact, because if you include those things via payroll, then the employer is going to suffer the pay as you earn and NIC on what you've just provided them, which kind of takes away from the value, I guess, of the benefit a little bit from an employee's perspective, anyway. And so, what many employers do in that position, they say, right, we're going to pick up the tax on the benefit as well, this tax on the tax on the tax, and that's the gross up. So the grossed up tax or the grossed up income needs to be included via payroll, and the net result for the employee is that actually it's neutral from a payroll point of view, because the tax on the benefit in effect has been also settled via payroll. We'll go on to look at the mechanics of that in a little bit very shortly. I thought it would be a useful one just to revisit, because I know that many payroll software applications out there run gross ups, but I think it's useful understanding some of the theory and mechanics behind it, particularly when it comes to checking calculations and making sure things are working as they should. So that's reimbursed expenses. If the employer pays directly, so let's say in the example I give there, the employer said, okay, you don't have to nip out to bring your own booze and cheese. We're going to provide that on your behalf. We're going to go out and buy that as the employer and then put it out for you and so on. Where that's a taxable benefit, then that will then be included on the form P11D. Why? Because you're not giving a cash amount via reimbursement now, you're actually paying it yourself as employer. So again, that would go on the P11D, but if as employer you're going to pick up the tax for the individual, then that would go through the payroll grossed up as before. That would be if the employer is providing directly. Slightly different if you're payrolling benefits, of course, because if the benefit's going via payroll, then you'd of course put it via payroll. But one thing to bear in mind is that you'll still need to pay Class 1A national insurance on the benefit, even where it's payrolled, and that will be calculated via the form P11D submitted via by the 6th of July following the end of each tax year. So a slightly different process there, depending on how you provide the benefit, and also then depending on whether you decide to pay the tax for the employee on that benefit. So just looking very briefly then at the actual gross up calculation. I'm not going to go through all of this, but I just wanted to include the example there, which I took from HMRC's guidance, and it helps really explain the mechanics of it. So you've got a reimbursement of £567 worth of taxable expense. And ordinarily the tax on that would be £181.44, tax and NIC, that is. Now, if the employer didn't pick that tax up, then the employee would end up paying the £181. So what many employers do in that position is say, listen, we want this tax neutral for you. We're paying for the monthly season ticket, so we don't want you paying the tax on that too. So the employer picks up the 181. So essentially you go through some steps there, which I set out, and you end up with what I call the grossed up tax amount. That's the step 5, the 266.82. That is the amount of tax plus the tax on the tax on the tax, the iterative formula I was talking about earlier. So that grossed up tax, you then add that to the actual value of the benefit, which is 567, and you get the 833.82. That's the total amount that then should go via payroll in order to leave the employee neutral. So once you've operated your 833.82, you end up back down at the 567 once you've operated pay as you earn and NIC. So the employee is left neutral and doesn't end up suffering tax via the payroll as a result of the provision of the monthly season ticket in that example there. So yeah, I thought those steps might be useful. And I always think, as I said, even if you've got software, do those things just to do a sense check now and again, and also make sure that in accordance with the earlier slide, that you're treating the gross ups and the way the expenses are reported, depending on how they are provided by the employer. So that's gross ups. I did want to mention that the consultation on umbrella companies, that has now closed. Umbrella companies, basically those companies which employ contractors and may send them to multiple engagements. The umbrella company is the company that's then responsible for operating pay as you earn NIC where it's due. That's the general concept. There is concern, certainly from HMRC's perspective, that umbrella companies aren't paying contractors properly and aren't accounting for pay as you earn NIC properly, and perhaps following some practices which are less than what is prescribed by tax law. So that consultation was really looking at the whole operation of umbrella companies, and my expectation is that we'll see the output of that consultation in the next 2 or 3 months from HMRC once it's reviewed everyone's kind of comments, as it were. So linked to that, I wanted to talk about off payroll working. So this is off payroll working comprises many things: agency work, managed service companies, self-employed. But one particular element I wanted to focus on today was IR35, because there was a couple of interesting reports I thought come out during the month, which I wanted to share with you. The first is this one, which is a report commissioned by HMRC, and it's the long-term effects of the off-payroll working rules reform for the public sector organizations. Now, this was the rule change in 2017, which basically said all public sector organizations, if you're engaging people via personal service company, it is no longer the personal service company's responsibility to assess whether IR35 applies or not and to be compliant from a pay-as-you-earn and NIC perspective. We're going to make that the engager's responsibility. That would be you, the company who's engaging the contractor, if that's the case. So the reforms came in the public sector, and I have to say that whilst they include a lot of statistics in the report, it actually paints quite a favourable picture of how the rules were implemented. Perhaps not surprising, that given that it's an HMRC report into itself. But it does paint it does point the fact that there was not too much disruption in the market, that there was a reasonable uptake of the check employment for status tax tool, that people found it easy to use. But hidden within that, there were some, I think, things that need to be worked on. And I think those were amplified by another, it wasn't a report this time, but a letter. And this letter was issued by the House of Lords subcommittee on finance in February. And I thought it was a really interesting read as well, and one to have a look through if you're interested in IR35 and employment status. Now, that is a lot more critical, I think, of the government and what's happening with regards to IR35. One of the things it points towards is the fact that the check employment for status tool, the CES tool, they're saying actually has some real deficiencies. The first thing is it doesn't take into account the nuances and plethora of case law out there. It doesn't include, for example, the case law test around mutuality of obligation. And actually, there is some statistics which say that actually it only is accurate in 50 to 60% of cases. Now, that's going to vary, and others would dispute that figure, no doubt. But the point being, which I think is right, is that it's very difficult to make a tool provide employers with an accurate determination of somebody's employment status, where that tool is trying to consolidate case law going back 100 years. I mean, it's a huge and tough task. And so I think what the committee is saying in the House of Lords is actually the government needs to make it a lot clearer, the fact that the CES tool is not a kind of black and white. It isn't always going to be right. And in fact, in 1/5 of cases, according to that report, it actually doesn't give a determination at all. So where does that leave employers? Well, actually with a struggle sometimes, because actually it is difficult for employers, especially if they're doing this internally on minimal budgets and without advice. It's difficult for employers to know conclusively whether somebody should be employed or self-employed for tax purposes, and therefore whether somebody should be on the payroll or doesn't need to be on the payroll. So they're basically lobbying the government, I think, to make things clearer from that perspective. The other thing that I thought was really interesting as well was the fact that they're saying there are too many private sector organizations who have simply taken the view that we can't be bothered with any of this. We're just going to make all our contractors employed. And I think there's criticism from the committee to say that that's not a good position to be in, because the idea of the employment status rules in IR35 is not always to say, right, we want to make everybody an employee. It's to make sure that the process is fair, that if somebody is employed for tax purposes, then they should be on the payroll. If they're not employed, then they don't need to be on the payroll, and they can be self-employed individual paying themselves dividends and so on. And I think what they're saying is really that kind of blanket approach is not great. It might be good for compliance, but actually it's not good for competitiveness. It's not good for the individuals being engaged as well, and shouldn't always be the case. People should be basing how they engage their contractors on commercial elements, rather than looking at purely tax. And I thought, the final one on that as well, which I think is a critical thing, and I think we're going to see some changes over certainly the next 2 or 3 years, is that employment status for tax is separate from employment status for employment law. So for things like rights, national minimum wage, holiday pay, sick pay, etc., which is as the committee points out, is a weird position to be in, because it means that you can be self-employed, say like the Uber drivers for tax purposes, but then be deemed workers for employment law purposes, which means they have certain rights, under employment law. And that's really confusing for employers, because you check employment status for tax and think, okay, I've got it. This is how we should be treating these people. But they may have rights under employment law. And that in itself is a risk for employers when they're engaging with people, as contractors. So I thought some interesting things coming out there. So I'll provide links afterwards to anyone who wants those reports. They're an interesting read, and there's obviously a lot of detail in there which we've not got time to cover today, but I really wanted to highlight that, given the importance of payroll working to many employers up and down the country. Finally, just wanted to mention that the student loan thresholds have been announced. I've included them in the slide pack. I won't go through them. You can read them after this, but they're all there now, just for the rates that will apply from April onwards. Some quick points now. We're coming up to year end. Of course, last FPS is due this month. Don't forget to set the indicator to say it's your last FPS. I do understand that there is some problems with technology whereby that indicator doesn't feature in the FPS, so you can't do it that way. So what HMRC have said is that actually, if you can't select the indicator as part of the FPS to say it's your last one of the tax year, then you should do that. You should submit an EPS, which basically sets that indication. But either way, letting the revenue know that it's your final one of the year. Equally, if you're not paying anything in your last pay period, then you should still set the indicator as part of an EPS in order to let the revenue know that they can then finalize their records from an employee and employer perspective. If you're going to register, we talked about payrolling of benefits earlier. If you're going to register for payroll of benefits for next year, you've got this month to do it, basically. So remember to do that before the end of this tax year. Otherwise, you won't be able to do that next year. If you've got short-term business visitors from overseas who've arrived in the UK this year, then you've got, again, until the end of this tax year to apply for an agreement with HMRC in order to relax pay as you earn. If you've got business visitors and you haven't got that agreement, then even if exemptions are possible under double tax treaties, then you may still be liable for penalties. And also, just be aware that there are some increasing rates coming in with national minimum wage, national insurance, statutory sick pay, and so on. We'll have a little look at those in the next coming slides. There's the student loan thresholds, just for people to have a look at if it's needed. So that's a quick tax update of what's the things that have happened this month and things that are upcoming down the line. Quick look at legal news then. So the headline rate for national minimum wage is increasing to £9.50 from next month, which may well have a knock-on impact on what employers are paying other people as well. Of course, if you've got people who are on statutory maternity pay, they're not forgetting that you may need to recalculate your SMP given the rise in the national minimum wage, or indeed any other pay rises during the period that individuals are receiving SMP. Statutory family leave payments are increasing to £156.66 from April 2022. So that would include things like statutory maternity pay, adoption pay, shared parental leave, and so on. So increases there. Sick pay is increasing by a whopping £3 to £99.35 per week. One flag, if you have less than 250 people on your payroll as of 30th of November 2021, then do remember that you can reclaim up to 2 weeks of statutory sick pay that you've paid out for anyone who was sick after 21st of December 2021 due to COVID. So that may be useful for smaller employees. As I said, less than 250 people on your payroll as of 30th of November last year, and you can reclaim some statutory sick pay up to 2 weeks for people who are off with COVID. So that may be of use to some people on the call. And finally, financial award for compensation and unfair dismissal. That's increasing several £1,000 to 93,878, or 52 weeks of salary if lower. So those are the things coming down the line for the new tax year. So more widely then, what's in the legal landscape? Well, we've got the employment bill coming up, and we do in coming sessions, we've got some lawyers who are going to speak a little bit more about these things and what they might mean for employers. I'm not a lawyer, I'm a tax expert, but I wanted to flag the employment bill because it did start the process through Parliament in 2019. It was put on the shelf due to COVID, but has now been reinitiated, as it were, and so that will we expect come into law over the next year, and has some significant changes to the law in various areas when it comes to employment rights. So more on that in the coming months. As I said, we've got a lawyer coming along to explain what it contains and what that might mean. Vaccinations. There is some talk that vaccinations may well become a mandatory part of the law for employers. There have been several favourable rulings towards the government's case for essentially having mandatory vaccinations as part of your employment obligations. So that's a potential for later this year, but we're obviously still watching that. Other things which are progressing: ethnicity pay gap reporting. There's some movements towards that, making it mandatory and statutory. Duty to prevent sexual harassment in the workplace, and also menopause in the workplace as well, putting that on a statutory footing, and having it as a protected characteristic. So those things are on the kind of, I guess, longer term agenda. And thank you very much to Emma Clark of Keystone Law for providing that kind of update and news. We'll be certainly exploring those things a little bit more detail in coming months. So as we move towards the end, then I just wanted to make a final, I suppose, or say a final few words. I always include a little insight spot on things out there that can trigger non-compliance or can lead to non-compliance. And the area I was going to cover was non-resident directors. So this is where you're a UK company, but on your board is a director who lives and is resident overseas, but comes to the UK to attend board meetings. Now, many companies in the UK are in that position. So you've got a director maybe working with a parent company, but they come to the UK to sit on the board of a subsidiary company in the UK. And that director may come 2-3 times a year, might be just once a year. But the point is, with director duties, they are taxable in the UK. So any duties which are performed as a statutory director of a UK company, so they include board meetings, preparation for board meetings, perhaps meeting the auditors, those are taxable duties and will trigger a pay-as-you-earn obligation. Lots of employers miss that. Why? Because actually often these directors are just paid one salary from an overseas parent company, and therefore the UK subsidiary thinks, well, we don't need to do anything because they're not being paid here, they're not on our payroll. But that's not correct. Essentially, what triggers the tax in those cases is the fact that you've got a non-resident performing duties in the UK as a director. Those are taxable, they're subject to pay-as-you-earn. And what HMRC would expect is that essentially you would apportion some part of that individual's overseas income and then subject that to pay as you earn. And the basic line is that these directors are not doing it for free. They're attending board meetings in the UK, and they're actually part of their wider remuneration overseas is actually account for the fact that they're performing those duties. So one to watch out for, because if you're audited, the revenue can look back 4 years for pay as you earn, up to 6 years for NIC. So you can find yourself in the position where you're on a lot of back tax plus penalties plus interest as well. And obviously you probably have an unhappy director at the end of it, because they will say, well, nobody told me. So do check your boards, see if you've got non-resident directors, and then just work out whether you're being compliant from a pay-as-you-earn perspective. Final thing, there is a concession for national insurance. It's in NIM 12013. So have a look at that. It provides a concession where directors are coming to the UK, I think, where the board meeting lasts for 2 weeks or less, where there's just one board meeting, or there's 10 board meetings lasting 2 days or less. So there's a concession. Have a look at that, which may apply to some of your people. So that's everything I wanted to cover today. As always, if you've got questions or things you're interested in or want to have a chat about, then do contact Mel or I, and very happy to pick that up with you afterwards. Back to you in the studio, Mel.
Thank you. I'm just waiting for the dogs to start barking. That's thinking that they haven't barked all the way through. We have had a couple of questions, so obviously we've run out of time, but we'll come back to you. So you know who you are that has contacted me directly. We will come back to you. You mentioned the situation in Ukraine at the beginning of today's session. We've had a number of our members just asking how each other's paying, people in Ukraine or even Russia, how people are dealing with it. So it's obviously an awful situation, and what we've organised is at 4 o'clock today on Zoom, just to have an open meeting, because we don't have any specialists as such that can answer any questions, because it's, you know, an awful current situation that everyone's trying to work out what to do. But we've got the community together to discuss what people have done, what solutions maybe they found, or just to discuss, you know, what their situation is. And I hope we do have somebody from a payments organisation that may be able to, you know, give us some tips or advice. So you can find that link if you are interested in attending. There is a link on my profile on LinkedIn. Contact me or DM me through LinkedIn and I can share that with you. So it's not just a GPA members forum. We've opened it up for everyone, just so that you can talk to other payroll professionals about what your concerns are, and maybe anything that any tips you can provide or anything that you can help with. So thanks. So sorry, just hijacked the end of that then, Lee, sorry about that. But thanks so much. Honestly, great advice. We will be having another session in a month's time. I will add that to our LinkedIn profile. So for those of you that are new to this session, look out for next month's one. And as Lee said, you've got speakers joining us as well. Yeah. Okay, so thanks again, and we look forward to seeing you soon. Thank you.
Thank you.